SJC-12706 in the matter of an impounded case.
Mr. Falkner, good morning.
Good morning. Mr. Chief Justice, and may it please the court, the first reported question should be answered no. General Laws, Chapter 276, Section 58B, plainly does not apply to pretrial probation as a disposition under Commonwealth versus Tim T. Section 58B, by its plain terms, governs revocation of pretrial release as a matter of conditions. And although it refers to conditions set under Section 87, clearly does not apply to a dispositionary probation. The statute specifically says that a person who has been released after a hearing shall be subject to a revocation of release and an order of detention. The judicial officer shall enter an order of revocation and detention if after a hearing the court makes two different findings. And the first one is that there's probable cause that there's a new crime. And the second one is that there are no conditions of release that will reasonably assure that the person will not pose a danger to himself or to the community. That has nothing to do with pretrial probation under Commonwealth versus Tim T, where those conditions are not conditions of release, but conditions of rehabilitation, conditions under which, if the probationer complies with those conditions, the case will be dismissed.
But isn't a pretrial probation both a proposed or conditional disposition and an order of release? Because you were released before trial, and the case will be dismissed ultimately upon the condition that you comply with all of the conditions of pretrial probation.
Well, in this case, one can look at the docket and see that the juvenile was arrested and charged and arraigned and released at the beginning of the case. Later on, at the time of disposition, in this case, I believe it's the second round of pretrial probation that's at issue began in June. At that time of that order, he had already been released. That order was a disposition of the case. So he wasn't being released at that time. He was already released. The Commonwealth made an agreement to recommend pretrial probation to the judge. The juvenile made an agreement with the Commonwealth that he would accept that disposition. The parties presented that disposition, and the judge ordered that those conditions of pretrial probation go into effect. And under Commonwealth versus Tim T, that was a disposition of the case at that point in time.
Yeah, but your position then is that even if this juvenile, well, he did, commits, or I'm sorry, has probable cause to believe he committed a crime, and if the judge had said, well, both of the conditions are satisfied under 58B, and therefore I'm going to revoke his release and order that he be held, that he would still remain on pretrial probation?
I'm not
okay,
sure that I follow.
Okay, let's, a juvenile, put aside yours. A juvenile is released on pretrial probation. A month later, the juvenile is arrested for a crime and therefore brought before the court under 58B. The court makes findings under subsection 1 that there's probable cause to believe that the person has committed a crime, and that the judge finds by preponderance that there are no conditions of release that will reasonably assure, and therefore says, I'm going to now hold you for up to 90 days as you await trial on this. You're saying that the pretrial, pretrial probation means that he ultimately will still be released at the conclusion of the probationary period? No, he's in custody for some part of that.
Well, I'm not sure that a person is released on conditions at the time while they're on pretrial probation. So the argument is that Section 58B flat out doesn't apply. If somebody is on pretrial probation as a disposition, and that's been ordered by a court, he's no longer has a pending case. That case has been disposed at that time by an order of the court. The revocation of that is not governed by statute. The revocation, however, Tim T does make clear the Section 58B pertains to detention. Tim T makes clear that the consequence of a violation of pretrial probation as a disposition of the case is restoration of the case to the trial track. Doesn't say anything about detention or anything like that. Now, that doesn't mean if the pretrial probation has been appropriately revoked and the case is returned to the trial track, certainly the judge at that point, under Section 58, 58A, 58B, Section 87, any of the bail statutes that apply obviously would apply at the time that the case has been returned to the trial track. But that's different from revoking for a violation of conditions of pretrial release, because these aren't conditions of pretrial release.
I think that the argument that pretrial probation is a disposition is where there's some difficulty with response to that question. So if you're on pretrial probation, first of all, and you commit another offense while on release, you can have a bail revocation because you still have a pending case. The case is pending. The pretrial probation turns into a disposition if you satisfy the conditions of the general continuance.
Well, I suppose when it is a disposition, when it isn't, is for this court to be deciding in this case. But what happens practically under Commonwealth versus Tim T is at the time the judge makes that order, that is an order that goes into effect and is self-executing unless there were to be a violation of that order. So if a judge orders the defendant onto pretrial probation with the agreement of the prosecution, as is permissible under Commonwealth versus Tim T, and the juvenile complies with those conditions throughout the period, the case is to be dismissed at the end of that period.
Isn't that the point? The juvenile didn't comply with the conditions, so the order is no longer in effect, right?
Well, the issue becomes, how do we determine whether he was in compliance with those conditions or not? That's what's at issue in this case. So to say that he didn't comply with him is jumping forward. The question is that there never was any proof of any kind that he did not comply with those conditions of release.
So you're saying it's a disposition in the same way that a continuance without a finding is a disposition?
I think that's correct, and this court has repeatedly found that a continuance without a finding is a disposition.
And it may be dismissed 6 months from when it enters, but it's a disposition at the time it's imposed.
That's correct.
And that's your analogy?
That's exactly correct. And I think under Commonwealth versus Tim T, that is a correct analysis of it. It's not a disposition at the time of the dismissal. It's a disposition at the time that the judge enters that order. And I think the fact that and that's driven home in the record in this case, we have the order of it itself. It's an order of pretrial probation with a start date and an end date, just like any other order of probation would be, just like it would be with a continuance without a finding.
I guess that the distinction is in a typical continuance without a finding, there's no conditions attached. I guess it's always keep out of trouble, right?
I'm not sure that's the case. Pretrial probation, continuance without a finding often is supervised by a probation department and often has conditions in addition to the...
But don't you have to have a guilty plea or an admission for the quaff? You don't need that for the pretrial probation, right?
Agreed. Yes, that's correct.
That's why they're different paths, right?
They are different paths. The path of pretrial probation is set forth in the case law as opposed to by statute, but the practical effect is the same. Commonwealth versus Tim T, again, authorizes a judge to make this order so long as the Commonwealth agrees to it, and that's what the Commonwealth in this case did. And the Commonwealth's agreement
So you look at when the Commonwealth agrees, they've given up on that distinction, that it should be treated just like a quaff, because they don't have to go that route, right?
Right, the Commonwealth does not need to agree to pretrial probation. In fact, it's a condition precedent under Article 30 for pretrial probation under Commonwealth versus Tim T, that the Commonwealth does agree to that as a disposition, but that is what occurred in this case.
If you get what you want here, you're going to pressure the Commonwealth into requiring quaffs then, right?
Well, I'm not sure that's true. The Commonwealth's position below, it seems to press that position here, is that pretrial probation is just simply an act of largesse, that the Commonwealth doesn't ever need to do that. But the fact of the matter is, it's a negotiated disposition. There's reasons why the Commonwealth may choose to enter into pretrial probation that may have to do with the relative culpability of the juvenile in this case, and we know the purpose of the juvenile court is rehabilitation. It may have to do with the strength of the Commonwealth's case. So there's all kinds of reasons why the Commonwealth may choose to enter into pretrial probation.
I guess it goes to the consequences of the breach, right? Because now you want to up the ante from past practice.
That's another part, it's another place where I'm not sure, there's no evidence in the record, and there's no case law to date as to what is the proper practice.
Well,
So-
but Judge Blitzman, very experienced, visceral reaction is the exact same one I would have had, which is, oh, Section 87, JJ, we said covered 87. JJ gets written into an amendment into 87. There's a revocation issue. Oh, that means we look at 58B, standard is preponderance. That's exactly how my mind would have worked as quickly as one of the most experienced juvenile court judges worked in this case, because everybody understands that pretrial probation, JJ, look to for 87 to 58B. Now, everyone may have been doing it wrong, and Judge Blitzman does a great job reporting this. Everyone may have been doing it wrong, but when you say it's not past practice, I mean, that's just the way everyone responds to that situation.
It certainly is the way that Judge Blitzman responded to the situation, and I'm not saying that the response was in any way, I'm not criticizing the response. I'm just suggesting
I'm
that.
not criticizing your argument. It's a really important, I'm just saying that, you know, it hasn't been that long since I was doing this. It's just everyone assumed that JJ applies to Section 87 pretrial probation issues.
Right, but I think once you read Section 58B and compare the language of Section 58B to the language in Commonwealth versus Tim T, there's no way that this statute can possibly be applied to Commonwealth versus Tim T, where the consequences of that revocation or restoration to the trial list. Commonwealth versus Tim T doesn't say anything about the consequences being detention. Obviously, once that case is returned to the trial list, there's an issue of bail, and a judge could certainly set a bail or hold someone without bail, follow any of the bail statutes.
Yeah, it's not your client's issue, but Justice Kafker, I had the same concern, which is that we're upping the ante so much on pretrial probation that what's going to happen to a very useful, what I would say is not a disposition, but a pretrial conditional circumstance.
So I guess my second response to that is, to the extent that it does up the ante, the question is how far does it truly up the ante? Commonwealth versus Durling allows for police reports to be the sole basis of a probation violation hearing, so long as they're substantially reliable. So we're not talking about necessarily witnesses coming in or any elaborate process. That all that's necessary is for there to be some evidence that complies with the Durling standards.
You don't want Durlin light, though. You want Durlin.
Yeah.
Right? So I don't think the next person who has it is going to say, well, it's Durlin light. They're going to say, I needed discovery, I needed to cross-examine, I need argument. We're really talking about two fundamental things from what past practice is, arguably, and what you're looking for.
That's true, but I don't believe that Durling provides a right of access to discovery. It doesn't say anything about that. Notice and an opportunity to defend yourself. If there are witnesses that are favorable to the juvenile that say, he wasn't here, he was in another location, he should be able to present that evidence. But in terms of the burden on the probation department, in the vast majority of cases, it's going to be nothing more than presenting a police report.
So tell me what your world would look like. So there's pretrial probation, a juvenile commits or is arrested for a crime. You would say there has to be then a revocation hearing. Commonwealth would have to prove by a preponderance that there was a crime committed. In that case, the judge would say, okay, I'm revoking the pretrial probation, and the case was gonna be now set for trial. And is he then do you then go to 58B to determine whether or not he's released pending trial, or is 58B, in your view, have no bearing, and therefore somebody on pretrial probation could never be held under 58B?
I think the latter is correct. At that point, we're talking about a bail hearing under Section 58 or 42A, or conditions being set under Section 87. There are all kinds of, or even Section 58A. There are all kinds of statutory mechanisms to hold someone on bail if they need to be held, or to hold someone without bail. But Section 58B applies to people who have pending cases, who have been released on pretrial conditions of release, and which is very different from conditions, rehabilitative conditions that have been set by a court as a disposition of the case. And if somebody hasn't been released under pretrial conditions of release, which I think have to be looked at very differently, they have very different purposes. So I don't believe that 58B plays any role at that stage of the proceedings.
Okay, thank you.
Thank you.
Mr. Ferriter.
Good morning. Timothy Ferriter, Assistant District Attorney for Middlesex on behalf of the Commonwealth. Considering the interests involved in a pretrial probation revocation, due process doesn't require a full post-trial probation revocation Durling-type proceeding. In this case, I want to start with the interest of the Commonwealth in this case, and the interest of the Commonwealth is a practical one. There hasn't been a disposition of this case. It's conditional in that the pretrial probation might lead to a dismissal in the future. But if there's an allegation that a person has committed a new offense or violated any of the conditions, the Commonwealth has an interest in efficiently getting that case back onto the trial list. Tim T recognizes the risks the Commonwealth is taking with the delayed prosecution, and therefore, just like in 58B or 58, the hearing to revoke the trial probation should go along with the second arraignment, should be that day. And unlike post-trial probation revocation, which calls for an initial surrender followed by a final surrender, and Durling's an example where the initial surrender was in May and the final surrender is October, the Commonwealth shouldn't suffer further delay when there's been an allegation that someone has committed a new offense.
So you're saying the mere allegation of a violation of probation suffices to release the Commonwealth from its obligation?
No. When there's an allegation, it's the timing. One of the Commonwealth's concerns is the timing of the hearing. And just like in a pretrial release revocation where that hearing is typically held at the arraignment, at the same time as the arraignment, we would want the pretrial probation revocation hearing held expeditiously, because the Commonwealth would then have to go and try the case that was supposed to be dismissed if pretrial probation was complied with.
Okay, so help me, I'm not sure I understand. So Commonwealth agrees to pretrial probation
Correct.
for a juvenile. A juvenile is then arrested for a crime. You would say there should be a 58B hearing?
I agree that 58B doesn't strictly apply because pretrial probation is a creature of common law and there's no statute that directly addresses it. But we should look to guidance from 58B because you're in a similar situation. When you're on release or you're on pretrial probation, if there's a violation, that hearing should be held at the next arraignment, which is what normally happens with pretrial release revocation under 58B.
So, but it matters whether 58B applies, because the consequence of 58B, if both findings are made, is that the person's held.
Well, that's two different things, Your Honor. Whether the person's put back on the trial track is strictly based on whether or not there's a violation. If a person's going to be held under 58B, there's two findings, which is the person violated, and there's that second discretionary finding of dangerousness that the judge also has to make.
So you're saying this hearing that is held after an allegation of a violation is not a 58B hearing? it's something else?
No, it's a hearing to revoke pretrial probation, but at the same time, there could be a pretrial release revocation proceeding, as it actually happened in this case. At the same time, at the arraignment, that was the violation, the Commonwealth both moved to put the case on the trial track, back on the trial track, and moved to revoke release. And I don't think there's any reason to have two separate hearings. They can both be done at the arraignment for what would be the violation.
But you're saying they're separate and distinct findings by the judge. The first finding is
Well, they're the same.
pretrial probation is revoked. The second
Yes.
finding is a 58B finding.
Correct, the result is different. The first finding under 58B, probable cause that a new crime has occurred, is the same finding that would be in the pretrial probation. Though that finding would be the same, but then for 58B to be held, it is a second discretionary finding that also has to be made.
So, but the finding then you're saying is probable cause.
Correct.
And where do we find?
This is where I'd ask you to take guidance from 58B and Section 58. It's not strictly, it doesn't strictly apply to pretrial probation, but I think the court, as it did in Jake J., should take guidance from 58B in this situation, given that, and not the preponderance standard that's required to revoke post-conviction probation, given the interest at stake. I think the juvenile is mistaken when he says that the interests of pretrial probation and post-trial probation are the same. Post-trial probation is part of a defendant's sentence, and the consequence of a violation is possible incarceration up to the maximum sentence. For pretrial probation, the only consequence is that the case is put back on the trial track, and the defendant will, of course, have the full array of rights.
Didn't you just say that you were asking for two things, not just the revocation of probation, but the idea that he was going to be incarcerated?
You can ask for both. I'm not saying that you have to ask for both.
You did ask for both. and
In
you're
this case,
saying-
we did,
You're saying that that
yes.
is not a consequence of having,
That's a different consequence. If you violate the terms of your pretrial release, you can be held under 58B. But here, there's two consequences when you're on pretrial probation that could occur. You can be put back on the trial track, and if the Commonwealth also moves, you can be held, but I think those are two
They could be
distinct
they could be
results.
two relatively minor offenses. Both the reason why you're on pretrial
Correct.
probation and then
In that case, we probably wouldn't move under 58B to have them held, but you can have them put back on the trial track. Both are under the discretion of the Commonwealth, but there's no reason to have
in the
two separate
discretion of
hearings.
in the discretion of the judge to hold or not hold.
Correct, discretion of the judge to hold or not hold. But in the
So your probable cause standard it has really very little to do with 58B. It's really a Matthews versus Eldridge due process analysis, right?
correct, and I think the guidance for that comes from 58B. And I think what we don't want to have happen under the juvenile's proposal is to have a Durling situation, where it's an initial surrender and a final surrender, which could result in two hearings which would essentially be the same, a 58B hearing to revoke pretrial probation, to revoke pretrial release, and then essentially the same hearing sometime later to revoke pretrial probation. I think that would just be inefficient, particularly where there hasn't been a disposition and the Commonwealth has to move the case forward again. There's no need for further delay.
And there's hardly any consistency as to the interpretation of Commonwealth versus Durling at final violation hearings either, and how much is required.
I think there's definitely some variance by who's holding the hearing.
Yeah.
So if you have, there's pretrial probation, there's an arrest, you're saying if the judge finds probable cause, even if the judge would not find that there are no conditions of release that would reasonably assure the person to return, that then allows, that mandates the judge to say pretrial probation is over, or it allows the DA to be released from their commitment?
I think those are the same things, Your Honor.
Well, no, because the judge may say, I actually think this is not a serious enough crime to change anything.
I don't think the judge has that discretion under Tim T. If there's been a violation, if there's been a new crime committed, it's back to the Commonwealth to determine how it wants to go forward with the case.
What about a violation of probation when the probationer is late? It's a technical violation.
You mean late to court? I
Yeah,
don't understand.
no, like, some technical violation and the judge says, come on.
Well, I think it would be, the Commonwealth wouldn't likely move to revoke pretrial probation, but under Tim T, it's still the discretion of the Commonwealth first implement pretrial probation, and if there's a violation, to continue it or to try to move to revoke. I think that would go to the Commonwealth discretion. And I don't think the court overseeing it has discretion to continue probation if there's been a violation, to add conditions, to lengthen probation. I think it should go back to the Commonwealth under Tim T to determine what it wants to do with the case. Either, like in this case, put the person back on pretrial probation, as we did twice, or to go forward with trial.
It's the Commonwealth's grace theory, right?
Well, it's not quite the Commonwealth's grace theory, but I think it is, under Tim T, it's the Commonwealth's discretion how it moves forward with the case, whether it wants to move forward or not, whether it wants to put someone on pretrial probation. And once the pretrial probation is violated, if it's violated, it goes back to the Commonwealth to determine again what to do with the case.
But the issue is not whether there's a violation. The issue is what the standard of proof is going to be, whether it's going to be a probable cause or preponderance. So your brother agrees that if there's a violation, you can be released. He says it's by preponderance after a Durling hearing. You say, no, it's probable cause for any violation, whether it be a crime or...
Well, to be consistent with 58B, I think it would be clear and convincing for other violations, but just like in Commonwealth versus Jake J., where the violation was not obeying with school, there wasn't an evidentiary hearing. This court found it was sufficient just for the school reports to be accepted as hearsay, and that was sufficient to find a violation. I think the real issue the Commonwealth has is how much more time it's going to take in between the hearings, and should it be done at arraignment, or should we follow the full Durling process and have the initial surrender and a final surrender in an evidentiary hearing? I would argue, similar to Paquette in 58, that the hearing should be an evidentiary hearing should be at the discretion of the judge to revoke pretrial probation, but not mandated or required, just as it is in 58 and 58B.
I'm still puzzled, because you make the argument about a liberty interest, and I understand a liberty interest is not great if the consequence is only to have the trial, basically be back on the trial track. Liberty interest is quite different, though, if there's a possibility of being being released, not having the opportunity to be on probation anymore.
Correct. So I agree with that. There isn't a liberty interest at stake just to revoke pretrial probation. The only thing consequence is to put a case back on the trial track, which is why the Commonwealth believes a lesser standard, due process requires a lesser standard where there's less at stake for the juvenile than there is in the post-conviction probation proceeding, where the consequence could be the maximum sentence. Therefore, due process doesn't require everything that's required in post-conviction probation
But
revocation.
the fact that there's a possibility of incarceration does sort of raise the ante a little bit, doesn't it?
Yes, but to get to the incarceration, there'd have to be a trial where the defendant would, of course, have the full array of
Well, if you're
constitutional...
revoking probation, what happens?
Pre-trial or post-trial?
Pre-trial.
He's getting put back on the trial list.
That's the only consequence?
So the only consequence is to get put back on the trial track, and he's going to have the full array of constitutional and procedural protections that go with that.
And any bail decision is an independent bail decision.
Correct.
That would
There are
have its own constitutional protections.
Correct. Revoking pretrial release and revoking pretrial probation are two different decisions, but they're very similar. And there shouldn't be two separate hearings if they're going to be done at the same time.
So effectively, you're asking us to essentially revise the conditions of release to, or at least make what you think to be implicit explicit, is that, Your Honor, the Commonwealth agrees to pretrial probation on the condition that this person, that there's not probable cause of any of the following violations of probation.
So there is,
Generally, the conditions of probation require preponderance.
correct.
And you say, okay, he's on pretrial release as long as he does commit no crime and take his meds or whatever else.
Right.
You are saying that that should effectively be understood as a matter of law to say, Your Honor, we agree to pretrial probation provided there is no probable cause that he's committed another crime and no probable cause that he has not taken his meds.
Correct, Your Honor. I think the court should be guided by 58B in this circumstance where the interest is just being put back on the trial track. Or 58B, there's an actual liberty interest at stake, possible 60 or 90 days in jail, where this court has found that that process doesn't offend due process.
Same issue with 58, commit offense out on release on 58.
Correct.
The first finding is probable cause that you committed the new offense.
Correct. So the probable cause, and that could possibly have a liberty effect in that situation. And here the interest is even less, that you're just being placed on the trial track. And I think the court can be guided by 58 and 58B in this situation and not require all the protections that Durling requires.
Okay, thank you.
Thank you.
Ms. Pomponio?
Morning, Chief and fellow justices. May it please the court, Nina Pomponio on behalf of the Massachusetts Probation Service. The practical consequences of extending the due process requirements of a post-disposition violation of probation hearing to a pretrial probation proceeding is really arose with too many thorns. The treating pretrial probation as a disposition would have numerous collateral consequences that are not only onerous to probation and to the trial court, but also would be onerous to defendants and juveniles themselves. And I want to start by pointing out, I say defendants and juveniles because pretrial probation is a creature of the district court and BMC as well. It applies equally to adults as it does to juveniles. So the obvious consequences is the impact on resources. Probation officers will have to be conducting more hearings, and as my brother explained, potentially bifurcated hearings, so 2 hearings on each violation. And they would have to be conducted by the probation department as opposed to the Commonwealth, because 279.3 does require that a probation officer must present evidence, whereas the ADA may assist. So there is that impact, but I'd say the more hidden impact and the more troubling impact is that on the supervision of the probationers, pretrial probationers themselves. If pretrial probation is to be treated as a disposition, as the juvenile argues to you, then arguably they should be supervised as dispositional probationers, which would mean that we'd be further entangling these people into the criminal justice system and into the probation system when these are people that the Commonwealth hasn't even seen worthy of an admission. They're placing them on pretrial probation as somewhat of a test, as somewhat of a diversionary disposition, or not disposition thereof.
So you're telling us that pretrial probation should not be probation? It should be it could be unsupervised probation, or it could be supervised probation.
So there's a difference between, so there is statutorily post-disposition, supervised and unsupervised probation. Realistically, both are supervised. Your Honor, they are just supervised at different levels, but their pretrial release, the conditions of release are supervised differently and at a much lower level. And in the trial court has implemented a pretrial conditions of release guidance with a new form that has category A conditions and category B conditions. And in those category A conditions, those are truly unsupervised. You're not meeting with a probation officer. You're not subject to any sort of home visits. Or anything like that. They are truly unsupervised.
These are not conditions of release, but they're conditions of release. Well, that's, I guess, part of what we're deciding. But it is different, and probation recognizes that pretrial probation is a different disposition from just, I'm going to release you on these conditions.
Well, I don't necessarily believe it is, in fact, a disposition, Your Honor. I think as you all were discussing earlier, the disposition is the final dismissal. Whereas a quaff, the disposition happens at the time the defendant or juvenile makes the admission or does the plea of guilty, then is placed on probation, and at the end of the probation, if successfully completed, may be dismissed. Pretrial probation is holding the case open for a period of time. I believe the judge is doing the same thing in a pretrial probation as a judge is doing when releasing someone on conditions of release. They're releasing the person on the Section 87 conditions of release with theirs and the Commonwealth consent. The Commonwealth has made a promise that while the case is held open for that period of time, should the person successfully complete those conditions, that the Commonwealth will then move to dismiss the case at the end.
You're saying there are practical consequences of us holding this to a higher standard, but I'm confused. When someone's on pretrial probation, are you not doing anything with them?
No, actually how probation is supervising right now is somewhat inconsistent across the Commonwealth because of the ways pretrial probation is being treated inconsistently in the court system. In the juvenile court, it is tend to be looked at as a disposition and treated as somewhat separately. In the adult courts, it's often, they use the same conditions of release form, and it is very much treated as conditions of release, category A, category B, as I was explaining with the different levels of supervision. So the decision that you'll make on this case will ideally bring some consistency across the Commonwealth.
But I'm confused. The legal issue before us is in a pretrial disposition where there's an arrest, are we going to also require proof by a preponderance of the evidence or just probable cause? How is that decision, which is the only one we're really asked to make today, going to change your world if we do it preponderance versus probable cause?
I don't think that is the sole decision you're being asked to make today. There's also the question of what the requirements of due process are around that hearing. And the juvenile is arguing to you that it should be a full violation of probation hearing with all the Durling procedures applying, which arguably I think would then mean the district court and BMC rules of probation violations would apply, the juvenile court standing order on probation violations would apply. So that actually creates a lot of procedural hurdles that are impactful on probation, and I believe also impactful on juveniles and defendants. Another collateral consequence that could be seen is if pretrial probation was treated as a disposition, again, as the juvenile argued today that it should be treated just like a quaff, then arguably it should be reported to CORI. And other collateral agencies could begin treating pretrial probation as a disposition, the RMV, immigration, just like with how a quaff happened. You know, a quaff was found to be a disposition for immigration purposes and for the RMV. So those could be other collateral consequences that I think impact juveniles. And really, if our goal is to protect juveniles and defendants by offering them this pretrial probation, by offering them this deferred sentence, this is the wrong tool for the job. It's really, you know, we're looking for a due process solution to a legislative issue. And I would argue that the answer is not creating procedural hurdles that, as you identified, could risk pretrial probation from being offered anymore by the Commonwealth. The answer is really to look to things like the new juvenile diversion statute, which I just wanted to note, 11954A does also have a probable cause standard for the revocation of the new juvenile diversion statute. So that is why I would agree with my brother that probable cause is the appropriate standard. If I may just, I think, address your last question again, Justice Kafker, there may be a middle ground here that the court could find. If the court was inclined to adopt a preponderance of the evidence standard, this court could make very clear that pretrial probation is not a disposition and that the full Durling requirements of a hearing are not required. Instead, this court could say that the procedural protections of a bail revocation hearing that were tested in both Paquette and Josh J. Are the appropriate kind of procedural standards, which would be you do have a right to counsel, you do have a right to an evidentiary hearing at the judge's discretion, and there is the admissibility of reliable hearsay, but not the full violation of probation proceedings that would require bifurcated hearings, that would require probation officers to be conducting the hearings, and this may adequately balance the interests at stake that you have.
Well, it's going to change the landscape, though, because you have to, just because the hearsay is considered reliable for sufficiency, you still have to convince the judge by a preponderance of the evidence, and how much do you decide to put in and how much do you decide not to put in a busy first session in the district court.
Absolutely. I still think the preponderance standard is frankly too high for the interests at stake here under due process, but I think I wanted to offer the court just a middle ground that it doesn't have to be all or nothing, which I think the juvenile argued to you more of an all or nothing, that all the procedural protections of a post-disposition violation of probation hearing are required and not the bail revocation hearing. And I don't think it's necessarily so brightly in either, it doesn't have to be an either or.
But the Commonwealth is saying it's not only probable cause of a crime, but probable cause of a violation of the conditions. So if the conditions are commit no crimes and stay on your meds, and there's evidence that the person had a dirty urine or has not stayed on the meds, probation is still going to have to be coming and saying, Your Honor, there's at least probable cause of that.
Yes, I do believe my brother's argument was that we should follow the framework of 58B in that it would be clear and convincing for something that was not a new crime. But probation could be a witness, absolutely, if we were supervising a particular condition. But being a witness, if we're supervising a particular condition, is a very different level of responsibility in a case than if we are actually conducting the hearing. For example, if the violation was just a new crime, probation would have no involvement in the revocation hearing at all. Or if it was a Category A type condition where probation wasn't directly supervising, we would have no involvement in the hearing at all.
In contrast to a typical probation violation hearing where the probation officer essentially is the person prosecuting and the ADA is assisting, you want to make sure that the prosecutor is doing the prosecuting and you're basically a witness.
Exactly, and I do think that's appropriate given that it is still an open case. It is still the Commonwealth's case. and it is theirs to prosecute, not probation. So I do think that, given that, again, we're in the judiciary, not the executive branch, our role is very blurred. I think this appeal is illustration of how our role became very blurred as this moved up through the juvenile court.
Okay, thank you. Mr. Ferriter, we gave you 5 minutes because we gave probation time when they had done a letter and not an amicus brief. So now you know their argument. We'll give you a chance to address it.
Thank you. I think the most important point is that there was some suggestion that probation is not monitoring people that are put on pretrial probation. In the record in this case, at page 11, you can look at the order of pretrial conditions. In this case, the juvenile was on administrative probation, but there's a choice. There's a box for probation and a box for administrative probation. Clearly, there is supervision, and there's spaces for special conditions of probation. So this form demonstrates that probation officers do indeed supervise.
Administrative probation.
Administrative probation, in my experience in both the district courts and the juvenile courts, is the code word that people use is unsupervised probation, but essentially what it means is they're not meeting with somebody on a regular basis, once every 2 weeks or once a month. So it's not truly unsupervised, but administrative probation is a lesser standard. It's also borne out in the amicus brief, in the addendum, the probation disposition codes are put in there. And PTCOR is pretrial conditions of release, PTP is pretrial probation. In each category, there's PTCOR-A and PTCOR-B for basically what amounts to supervision and administrative. Pretrial probation A and pretrial probation B for administrative and for conditions that need to be supervised. So saying that pretrial conditions of release are the same thing as pretrial probation isn't even borne out in probation's own codes. The fact of the matter is they are supervising people that are on pretrial probation, whether it be dispositionary or whether it be as conditions of release. The other...
Would you address, she says if it is pretrial probation as a disposition, then arguably it would have to be identified as a disposition, and then we'd have to deal with what immigration and other folks would do with it as a disposition?
Yeah, I'm not sure that I understand that argument completely. First of all, my understanding of the Corey law is any case that is open, and it's been considered that while a continuance without a finding is going, the case is still open for the purpose of the Corey law. I think that's still already the case with regard to pretrial probation. With regard to immigration, it's not the fact that a quaff is a disposition that makes it a conviction for purposes of immigration. It's the fact that there's been an admission to sufficient facts that makes it a conviction for purpose of immigration law, and that doesn't happen in pretrial probation. So it simply is not, well, it can be a disposition, but it's not a conviction for immigration purposes as opposed to a continuance without a finding. Finally, with regard to the impact on resources, the probation's letter sets forth the number of cases that it supervises in both the district court and the juvenile court, and then specifically says they don't keep any statistics whatsoever as to how many of those cases are pretrial probation. So we don't know whether we're talking about 5% of their cases, 1% of their cases, 50% of their cases, but certainly it appears to be a small percentage of those cases. So there's really no way to gauge the actual impact on the resources of the probation department, and they've presented nothing to this court which is able to say that this would really be any real drain on their resources. And finally, I'd like to respond to the comment that the only consequence is to put it onto the trial list. We know that the consequence of being tried is a really important consequence. We know that because when we look at the double jeopardy case law, being put into jeopardy is such an important consequence that if it's a double jeopardy case, the motion to dismiss comes directly up into the appellate courts. So somebody is being put into jeopardy in a case where they've been excused from jeopardy. And that's a really serious consequence. And it's more than, it's not a consequence that should be treated lightly, I would suggest.
Would you address the compromise that was suggested by the probation department?
I'm not even sure that I'm entirely clear what the compromise was that was suggested. They say that it should be somewhere in the middle, but I'm not sure quite exactly what that compromise is. It seems to me that they're suggesting that the same findings be made from Section 58B. So I'm not really, they said it was a compromise, but I'm not sure exactly what it is that the compromise is.
All right, thank you.
Thank you.